this is a landmark order by the Delhi High Court, which is really in a sense an example for high courts across the country. The High Court, while giving bail to 3 students who had been arrested by the Delhi police and charged under the Tough Anti-Terror Act, the UAPA, where the Delhi High Court said today in giving them bail that the constitutionally guaranteed right to protest is not terrorism. You cannot blur the lines with terrorist activity. They also warned the police that frivolous use of the Anti-Terror Act by using these kind of incidents under it. The Delhi police had charged these students with provocative speeches and WhatsApp groups and blocking roads. They said it's a constitutional right to protest, and using this as claiming this as terror acts actually undermines the intent and purpose of Parliament when they passed the Tough Anti-Terror Act. This is a major embarrassment as well for the Delhi police, as their case has been virtually thrown out by the Delhi High Court.
3 students, Devangana Kalita, Natasha Narwal and Asif Iqbal Tanha, in their 20s and 30s, in Delhi's Tihar jail for over a year, a time when Natasha lost her father and only surviving parent to COVID, given bail only to perform his last rites. 2 of them, young women studying at JNU and part of a group which campaigns for campus freedoms. The third, a young man from Jamia Millia, charged by the police under the tough anti-terror law for allegedly masterminding violence during last year's Delhi riots, in which over 50 people died. Today, the Delhi High Court, in 3 separate orders, granted all 3 of them bail and importantly laid out a roadmap. The right to protest guaranteed under the Constitution is not terrorist activity. The court said it seems that in its anxiety to suppress dissent in the mind of the state, the line between constitutionally guaranteed right to protest and terrorist activity seems to be getting somewhat blurred. If this mindset gains traction, it would be a sad day for democracy.
Now, this is what this judgment puts on record very clearly, that this is not an act of terrorism because nobody is attacking the sovereignty of India. You can't keep these people in jail for indefinite periods of time. And that is why the court grants them bail today.
The court said that the police charges are at worst evidence that the accused took part in organizing protests, but there was no evidence that they incited violence or committed any terrorist acts as understood in the anti-terror law, the UAPA, warning against what it called the frivolous use of this tough act. The court said that foisting extremely grave and serious penal provisions engrafted in sections 15, 17 and 18 of UAPA frivolously upon people would undermine the intent and purpose of Parliament in enacting a law that is meant to address threats to the very existence of our nation. Wanton use of serious penal provisions would only trivialize them. Freedom after a year on charges the Delhi High Court has questioned the very basis of. For their families, it is a time that can never be returned, especially since a father couldn't see his daughter before his death.
हमारे लॉयर्स कह रहे थे कि हम ट्राई करेंगे कि जज सुन ले फ्राइडे संडे की इस केस को लेकर, जो कि नहीं हुआ। नताशा जेल से हमारी वीडियो कॉल का होता है 14 डेज या समथिंग, तो वो भी बंद है। तो जब हॉस्पिटलाइज कराया तो मेरे दिमाग में बस यही था कि एक बार तो कॉल करा दें कि कुछ भी हो सकता है।
It felt like this whole last year has felt like one nightmare that has developed into a worse nightmare instead of like ending. The notion that Devangana and Natasha have done the things that they've been accused of doing is just absurd.
Delhi High Court has also said that foundation of our nation cannot be shaken up by the protest by college students. UAPA is not to be used for usual offences. In New Delhi with Manu Nayar, Saurabh Shukla for NDTV.